Payman.
Thank you, Chair. Good afternoon. My line of questioning is around glasses fitted with cameras, in particular Ray Ban's Meta Wayfarer glasses. And from what we've read and understood recently, they're being used to covertly record people without their knowledge, often for social media posts. Now, in terms of both recording audio of conversations and filming them, could you walk me through the federal legalities of recording someone covertly without their permission?
I think it obviously raises privacy issues. So I'll ask the colleagues who are the expert in this space to talk to that issue.
Thank you.
Might just say, Senator, we can obviously talk about the provisions of the Privacy Act, but couldn't comment on its application in particular cases. And the regulator is the Office of the Australian Information Commissioner and Privacy Commissioner.
Thank you.
Thanks, Senator. Would it be possible for you to repeat the question while we were walking up?
Yeah, no, that's totally cool. I just wanted to get some information about the federal legalities of recording someone covertly without their permission, in particular when you've got Ray Ban's Meta Wayfarer glasses that's doing that, both recording audio of conversations and filming.
Thanks, Senator. Catherine Fitch, Assistant Secretary for Privacy Reform Task Force. Just in general, I understand there was a question on notice asked about this and answered by the department in writing at the last hearing, so I'll try to find that for you to give you some more information. But generally speaking, the Federal Privacy Act applies to regulated entities, not to individuals directly. So if a person was wearing one of these smart glasses and videoing somebody, they wouldn't be subject to protections under the Federal Privacy Act. There are, I think, some state and territory laws which might apply, relating to surveillance technologies and those sorts of things, but generally speaking, it would be outside the scope of the Privacy Act, with the exception of the newly legislated statutory tort that the government brought in its first tranche of privacy reform. So commencing, the legislation was passed at the end of 2024, but the new tort came into effect in June of last year, and where there are thresholds met for the tort, which relates to serious invasions of privacy and has a range of other criteria that must be established, then that could potentially apply.
So individuals cannot make complaints, but what happens on a federal level? Are there penalties for individuals who record others without permission?
It's not something that comes within the purview of Australia's federal privacy law. I can't speak to the content of state and territory privacy laws, but individuals wearing those technologies are not subject to the Privacy Act. Might be, if there was the possibility for an entity that was covered, there might be different rules that would apply, but that's not what you're asking.
No. And without going into, I guess, details of specific cases, how many complaints of recording without consent have been made in the last 12 months?
Senator, it's difficult to say. It might be a question that you could explore further with the Office of the Australian Information Commissioner this afternoon, but because they're not, as I've said, they're not within those situations that you're asking about are not within the purview of the Privacy Act, then technically that they wouldn't have jurisdiction to accept and investigate a complaint if it related to an individual's conduct.
Okay, and so can we say that the Attorney General's Department has no, I guess, not intention, but if it doesn't fall within your purview, does that mean you cannot take any action to address this issue?
Well, I think the question you're asking is a slightly broader one. What the evidence that I'm giving you is just that it's not a matter that's covered by Australia's federal privacy legislation. That's not to say that there might not be other relevant statutes that would apply, but I think primarily in the case you're referring to, it's state and territory law, not Commonwealth law.
Okay, so federally there isn't any protections for individuals who may be subjected to covert recording of their audio or being filmed, and that's something that falls within state and territory jurisdictions. Is that what you're saying?
I mean, I think, Senator, that's largely correct, although if it were to hit the seriousness thresholds and the other thresholds that have been legislated as part of the new privacy tort, then that might apply, but I'm not able to speak to specific situations.
Sure. What are those thresholds? Can you outline what would meet those thresholds? How serious must the offence be, or, especially if it's not within the federal jurisdiction?
Yeah, sure. Thanks, Senator. The new statutory tort for serious invasions of privacy by and large applies where the privacy invasion was serious, the plaintiff had a reasonable expectation of privacy under the circumstances, the conduct by the defendant was intentional or reckless, so not merely negligent conduct, and the public interest in the plaintiff's privacy outweighs any countervailing public interests. So that's a balancing test, and there are factors in the legislation that go to outline what should be considered.
And how does one go about making such complaints to see whether they meet the threshold or not?
They would, in the usual course of events, seek some legal advice and then make a claim to I think the jurisdiction applies in federal courts and state and territory courts also.
Okay. I think there's a few loopholes there, but thank you for the response.